It remains to be seen whether Vodafone and Gain Energy would be willing to accept this as an honorable settlement. If not, then the cases would continue to apply. The government has introduced a bill in the parliament which aims to amend the Income Tax Act. Specifically, the bill aims to nullify the 2012 retrospective amendment. The bill states that the amendment to Section 9(1)(I) will not apply to indirect transfers of Indian assets that were made on or before 28th May 2012. In simpler terms, the law on taxing the gains which arose out of indirect transfers of Indian assets shall now be prospective in nature. So it basically nullifies the retrospective aspect of Section 9(1)(I). And therefore the tax department can no longer pursue taxation claims against companies such as Vodafone and Gain Energy for its pre-2012 transactions. Now the question that arises is that will this bring the Vodafone and Gain Energy cases to an end? Well, the benefit which will be extended to these companies is subject to certain riders. For example, these companies will have to withdraw the legal claims that they have brought against India, and they also have to waive their right of bringing any such claim in the future. Another very important aspect is that the government will only return the principal amount and will not return the interest. So therefore, it remains to be seen whether Vodafone and Gain Energy would be willing to accept this as an honorable settlement. If not, then the cases would continue to apply. The other important point that we need to keep in mind is that this amendment has been triggered by the adverse ISDS decisions that were passed, that were rendered against India. It doesn't look like that India has brought in the amendment to the Income Tax Act in order to comply with the decisions of the Vodafone and Gain Energy Tribunal. I mean, the fact that India will only return the principal amount and not interest and other costs which the Gain Energy Tribunal has ordered very clearly reveals that India is not amending the law in order to comply with the international decisions, but is presenting this as a case of a domestic legal reform. It's important for us to keep in mind that India has been constantly saying that taxation is the right to tax is a sovereign right, and therefore it cannot be arbitrated before investment treaty arbitration tribunals. While it is true that right to tax is a sovereign right, but this right is subject to certain limitations. And this is precisely what the Gain Energy Tribunal had said. Going forward, it would be interesting to see how the foreign investors react to this particular move. On the whole, it would definitely lift the investor sentiment, but will it actually resolve or lead to the final end of these cases? That is something we will have to wait and watch.
Gain Energy, pursuant to that award, has instituted several proceedings across the world to enforce that award, and which includes seeking attachment of assets of the Indian government and the Indian PSUs. There is always a danger of liquidation of those assets once they are attached, and hence the Indian government was worried, and this is what probably has forced the Indian government's hand to bring about this amendment. Insofar as the likes of Cairn Energy are concerned, time will tell whether this offer is attractive enough for them to forego their interest, cost, and damage cost. Insofar as the first set of basket of cases is concerned, where the petitions are pending before High Court and Supreme Court, the companies will have to undertake a cost benefit analysis, a time value analysis, and reach at a final conclusion whether it's worth progressing with those cases or to withdraw those cases and have their principal refunded without interest as on date. The companies may find it attractive to take whatever is available on the table. One more concern which is being flagged in the Indian media is that this step was necessitated because of the attachment of assets. Probably a related concern and something which could have fast-tracked this bill is the fact that these companies have targeted the Indian assets and the assets of the PSUs which the government had already targeted for privatization and divestment. And hence, they had the potential to create an encumbrance over these prospective sale assets. The valuations were also affected because of these prospective encumbrances. This, in my view, has necessitated the bringing of this bill.
We are truthful, unafraid and independent because of you. Now you can help our reporting from the ground. Go to thequint.com, click Become a Member tab, choose a plan and pay. Because the truth is worth it.